You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Hello, and welcome to Best Practices with Kenny Berger. I am here in South Carolina and have a practice across the state. And our guest today is Marc Harwell from Tennessee. Marc, welcome to the podcast.
Thanks for having me, Kenny. I appreciate it.
Yeah, and thank you so much for being here. Marc, for folks who don't know you, we're going to be talking about mediation today from the perspective of a mediator, but you do more than mediations. Will you share with our audience a little bit about your background and your practice?
Sure, I'll be brief in that regard. I've been a practicing attorney for 35 years and have a wide, diverse civil defense background, primarily in the areas of construction, employment, catastrophic commercial, motor carrier litigation, and some insurance coverage work. And my mediation practice and my arbitration practice tend to track those large blocks of business.
Yeah, and when we were prepping for this call, when you mentioned your practice areas, I said, complicated stuff. And we talked about our mutual enjoyment of complicated legal questions and some of the fulfillment that comes with trying to navigate them.
Yeah, I find the more complex the cases, the more satisfying they are, because after you've been doing this for 35 years, you still want to be challenged, you still want to learn, and I find that to be the exciting part of the practice law, because we never ever get to the end game. It's always a development, it's always a practice, right?
Always. So Marc, how long have you been doing mediations in the role of mediator?
I've been a mediator since I think 2014. I would say that in the past 6 years, I've really focused my attention on developing my mediation practice.
And are you mediating cases only in Tennessee, or are you mediating cases outside of Tennessee as well?
No, if anything good came out of COVID, it was this Zoom platform that allows us to litigate remotely, mediate remotely, arbitrate remotely. So that Zoom platform's enabled me I've mediated a case pending in Oregon, a couple in Texas, a couple in Georgia, one in Florida. And those are the most far-reaching mediations I've handled outside of the state of Tennessee. And I've handled mediations across the length and breadth of the state of Tennessee.
Fantastic. And in today's episode, we're really going to break it down into 4 parts pertaining to mediation. And in that first part that we're going to talk about is preparing for mediation, the steps that an attorney can take to create a successful mediation process when the day or multi-day event comes. Tell us about that.
Well, I think the way you optimize the chances for success in mediation starts well before the opening negotiation. George Bernard Shaw is famous for saying the single biggest problem with communication is the illusion that it has taken place. And so often times as a mediator, I find that really well experienced attorneys forget the principal rule of negotiation or effective negotiation, which is communicating often and well. You can optimize your chance for success by communicating well, number one, with your adversary, number two, with the mediator, and number three, with your client. That communication needs to be done well in advance of the mediation for both the defense attorney and the plaintiff's attorney, in my opinion. Most corporate defendants, when insurance coverage is involved, they need no less than 30 days prior to mediation to be ready for the mediation. And 9 times out of 10, if anything of great consequence is shared with the defense attorney handling a matter that involves significant coverage issues or layers, is going to need, it's just not going to be effective. It's not going to move the needle if it's if it's within that 30-day window. And frankly, I think it's a good practice just to open the door of communication as a plaintiff's attorney, reach out to your brother on the other side and say, hey, how much time do you need in advance of this mediation so that I can make sure that I get you what you need in order to best discuss the case with your client. So I think that's wildly important. And then helping your mediator help you. It's amazing to me how often, and I get this shortcoming from well-experienced plaintiffs and from well-experienced defense attorneys that don't get the mediator significant information at least a day or two ahead of the mediation. I mean, I can work pretty quickly on the fly, but if you give me some time to digest what you're trying to help me understand, then I can only work better for you as a mediator. So that communication with the mediator, the advanced communication with your adversary, and then also doing a good job counseling your own client as both plaintiff's attorney and defense attorney on what the strengths of your case are, but also not sugarcoating the weaknesses of your case. So those are several factors that I think are really important to getting yourself set up and advance the mediation for success. And with respect to sharing that information, sharing the really consequential pieces of information that are crucial to the real risk analysis. And if you feel like you've got to hold back or are reluctant to share those crucial pieces of information, then ask yourself, is it ready? Is there something I need to do to get past this reluctance I have? Maybe I need to go ahead and take X, Y, Z deposition or just X deposition so that I've already got it locked down and I don't feel so reticent about sharing that crucial piece of information.
So, I've long heard about trying to get the folks, because I just do plaintiff's work, right? But long heard about trying to get folks on the other side, things at least 30 days in advance. It seems like the longer I've practiced, the larger that window has become, where now, anything of consequence that you want the folks to consider, trying to have it to them 45 or even 60 days in advance. What have you seen in that regard?
Yeah, I'm seeing that same trend, Kenny, and I think it's not surprising. I think with respect to defendants, they've been roundtabling for quite some time, but this roundtable practice, it's certainly being done by most of them. And I think now the use of AI is also impacting how cases are being evaluated. And if you can't or don't get the information to that adversary well in advance, then you run the risk of decisions being made. And people are curious in one regard. It's been my experience that once a person has made up his or her mind, it's hard to get the individual to retract or retreat from the position taken. And so if you can get the information into your adversary's hands before those decisions kind of get sadly set in stone, and then you're scrambling and working to get a refresh on the decision. I think that's the factor I'm seeing more often than not that's leading to this larger window of time.
Yeah, and in terms of optimizing the chance of resolution at mediation or sometime shortly after mediation, I've seen lawyers get so hung up on midpoints, and I'm just going to use some simple math. Plaintiff's lawyer, what they're really trying to do is settle a case between $400,000 and $600,000, and so the starting settlement offer is $1.2 million. Defense sees $1.2 million, says plaintiff's looking for $600,000. We're never going to pay $600,000. We want to pay something closer to $300,000. And I can, with a high degree of probability, tell you that for most plaintiffs' lawyers and most insurance carriers, that case is probably going to settle between $400,000 and $450,000 with no other information. Just because there's this dance, this artificial dance that occurs. What advice would you give to both sides about pre-mediation settlement offers, either coming from the plaintiff side or the defense side, and how to either capitalize on the notion of midpoints or help the other side properly disabuse themselves of a search for the midpoint, but knowing that it may be impossible to remove that number from their mind? It's kind of like, don't think of a pink elephant.
That's a good example. I think midpoints are the bane of my existence as a mediator when they're used too early to govern the move. And what I mean by that is, until parties get into the realm of reason, negotiations truly haven't begun in earnest, and I think you just wasted a bunch of time, capital, credibility, and patience. And so when I see either a defense attorney or a plaintiff's attorney, or oftentimes both, looking at a midpoint more than a reasoned demand or a reasoned offer, I just see trouble. I see frustration, and I see basically a time suck. So what I always want the litigators to do is be that voice of reason from the get-go, because in my opinion, when I'm an advocate or when I'm a mediator, I have one, the most crucial thing for me is my credibility. And I can't abandon my credibility for anything and anyone. So if I take a position and I start communicating my position and I'm incredible in the demand or in the ask, then I've ceded or potentially ceded the control of the negotiation to my adversary, who then has the opportunity to compare and contrast what my knucklehead opponent's doing, right? If my knucklehead opponent is at $10,000 on a case with $80,000 in hard meds, well, that's just stupid. Unless there's some crazy liability question where you're going, well, I don't think there's a chance in hell you get past, I'm going to get summary judgment. So maybe you've done this really early on, but you get the point. I mean, or if the plaintiff's attorney is at $500,000 over the statutory caps, then you're just kind of going, wow, where's that coming from? Where's the reasoned analysis? And so I really do like my litigants that come before me to speak in two ways. I want to hear a reasoned narrative, and I want a number that accompanies the reasoned narrative. And they've got to make sense together, because it's not about just what you're saying, it's the tone in which you're speaking it. And so I can have a really reasoned narrative, but I can have a number that's just off the wall from the narrative, and I've lost credibility because they're just not making sense. Does that make sense to you, Kenny?
1,000%. Yeah, absolutely. Absolutely. And they don't always match up. I mean, one of the things we talk about, and I got it from a prior podcast guest, Angela Bruno, along with her husband, Keith. But Angela is the one who handles, best as I can tell, the settlement side. And then Keith's the trial lawyer. And they make an amazing team. Keith got a near $1 billion verdict with Monsanto this year, and is coming on the podcast again pretty soon. Angela turned me on to a book called Getting to Yes, which was a product of the Harvard negotiation project. And the fourth key criteria in the negotiation there was taking a position based on objective criteria. And one of the things that I've seen almost always, I mean, close to 100% of the time, in openings, and I know we're going to talk about openings and starting negotiations in a moment, but you'll see an opening that's totally one-sided in a mediation. Sometimes you see totally one-sided openings in trial, and I think that does the process a disservice. And I think you're wasting time by not acknowledging as best as possible the 360, the entire picture. Now, it may be from our perspective, the defense's arguments are frivolous And if we came in and tried to make the same arguments, we get laughed out of a courtroom. And it may be that none of their points really hold up, and it truly is a how much case. But if there's legitimacy to any of the defense points, or if it's a defendant's presentation, whatever legitimate points plaintiff's counsel has, I think it helps to acknowledge those. And you may say, look, we believe the case value here is $1 million. And one of the reasons we think it's not a $2 million case in light of the damages is because y'all do have a pretty good argument on whatever it is in terms of causation, whatever it is here. That's why $1 million makes the most sense. And it makes the most sense because of A, B, C, D, E, and F. Now, if you'll outline for me the reasons it's not worth $1 million, I'll listen. But please don't offer me $100,000 just because you think the case is going to settle for 600, because it's not.
Yeah, I think that's a beautiful way to couch it. It's the most effective. When I see that, it makes me pleased as a mediator, or makes me pleased as an adversary, frankly, because what it's doing is it's real. You're gaining credibility because it's real. You're giving the mediator an opportunity to seize on points and argue points effectively with you or against you. And really, that's what you want at the end of the day. If you can't get resolution through mediation, at least learn something about your case so that you can try it better, right?
That's right. That's right.
One other thing I think is important about in getting to mediation is just making sure on these complex ones that you've really worked up what needs to be handled. And let me be more specific. Do you have is there a strong insurance coverage component that is going to be impactful to resolution of the liability component? Right. If it is, then it's going to be really difficult to achieve a good solution in mediation if the insurance carrier isn't at play in terms of the underlying case of liability, and if both the insured and the insurer aren't in mediation, either against each other or with each other, handling the coverage issues effectively. So it can be a lot to handle, but you can't stick your head in the sand and say, wow, I know that there's a deck action pending. I'm not going to deal with the insurance coverage question because I really don't like insurance coverage law, or I don't want to get involved in that, or I think my liability case is so strong, that's what I really care about. I just think it's a wasted opportunity to really achieve good solution at a crucial time going in advance of the mediation. I've got one right now that has been recommended, and I'm an advocate in this one. And I'm handling the insurance equation of it for the insurer. And there's an underlying lawsuit pending, and I think it's the plaintiff's attorney in the underlying lawsuit was the one that came to this mediator as an advocate and said, why don't we mediate both the coverage and the underlying at the same time? And then he articulated some very thoughtful points, Kenny, which were my client's most at risk right now because we have legitimate concerns about coverage. But when the risk is the greatest, that's also the most opportune time for parties to achieve settlement through mediation. And I latched onto that and recommended it to my client, and I hope we're going to go forward in that way.
I like it. I like it. Mark, let me ask you one other thing while we're on this topic. Most effective strategies leading up to mediation when you have multiple layers of coverage with different carriers. So let's just say, you got 3 layers of coverage, and we'll just say it's 1, 5, and 10. And it's not entirely clear if it's a $1 million case or a $12 million case. You just don't, the first layer is probably going to roll. The second layer might be the fight. But what have you seen as most effective in terms of bringing about resolution when you've got multiple layers of coverage and a wide range of potential 7-figure, 8-figure outcomes?
rolling up the sleeves and doing a lot of hard work in advance with a really knowledgeable mediator. And sometimes it might take more than one mediator. If you're in a jurisdiction and maybe the mediator just doesn't have, maybe the mediator's got a great handle on liability issues, tort issues, contract issues, but just doesn't have the steam when it comes to understanding really complex coverage questions. And so if you can't find somebody that can wear both hats really well and effectively, then go ahead and get a coverage mediator to be part of the total mediation, and then decide. More often than not, I've found that mediating the coverage issue first and then proceeding to the liability issue is oftentimes helpful. But sometimes when you're talking about the layer issues, you got to flip it and you've got to talk about what the exposures are in order to get the attention of the second and third layer. It's so multifaceted. So I hate that I'm not directly answering such a complicated question, but I think that there are a lot of different ways to skin the cat, and it oftentimes just depends upon, what is the strength of the liability case from the plaintiff's perspective? What is the threat to the insurance carrier? How do I get the attention of the second and third layer? How do I get the attention of the plaintiff's attorney who maybe isn't recognizing the strength of the coverage denial? So a lot of that comes into play, and it's always going to be changing because nothing stays the same when it's that complicated and difficult, right?
And I think just going back to your first point, which was communication.
Yeah. Yeah. It's just it's essential. And it's funny how oftentimes it's overlooked. I also think that getting to the mediation before you even open up the negotiations is what is the timing of it? Is it the right time? And that seems so basic, and that it could sound stupid, but I don't think it is. For instance, we talked about it earlier about why are you withholding information? Did you take the deposition that you've got to take in order to have a freer exchange of information? Has the motion for summary judgment been filed? And if it's been filed, then does it make good sense to just go ahead and have the mediation under the threat of a motion for summary judgment? Well, that's just going to depend really on a lot of factors that a good attorney is going to have to value and weigh. If the defense attorney's filed a motion for summary judgment, is jumping up and down on it, and is just so proud of the motion that's prepared, and then how successful is mediation going to be if that motion isn't heard, if an order isn't down denying it or granting it? I mean, just go ahead and at least know what you've got to know in order to get the right decision made for your client. In other cases, another example about timing is it too late or is it too soon? And what I mean by that is, if you're a plaintiff's attorney and you've got a case, it's just very limited exposure. I mean, you make a $50,000 case on a great day. Oh, my Lord in heaven, do you want to go 2 years down the road litigating that against the defense attorney when you're so upside down? That's probably not a wise use of the time. But if it's a $1 million case, then you've got a lot more latitude in deciding. Yeah, I trust this defense attorney to have opened up the doors to let me know what I truly need to know in order for us to fairly evaluate this case and get it done yesterday. Or is this an attorney I cannot trust? I've got to turn over every rock and stone in order to figure out where they're hiding stuff and what I haven't had access to. One of my greatest victories as an advocate was I had a wrongful death case that I was assigned by a major motor carrier, and this has been about 10 years ago, so it's old news, but I still think fondly of it. It was a horrific accident. It just made you want to cry. It would upset anyone reasonably. And so I reached out to the family, who then put me in touch with their attorney. And this is within a month or 2 months of the fatality. And I said, I'd really like to take a run at getting an early resolution of this through mediation with you. You could hear a long pause on the end of the line. He said, I'll get back to you, Mark. Lo and behold, he got back to me about 2 weeks later, and he said, "We're willing to move forward with you to mediation. And we got a mediation date set within 6 months of this wrongful death." I found out about 3 months after that mediation through a plaintiff attorney friend of mine. He said, "Good job on getting that one resolved, Harwell." I go, "How did you know about that?" He said, "Well, that attorney reached out to me, wanted to know what I thought of you, and I told him if he says it's gold, it's gold. You can trust him. You should proceed." And so that gave me greatest honor, because I not only helped the family of who lost their mother, help my client get resolution quickly. And so it was just a win-win. But I guess in a long answer, hopefully that story made some sense in answering the question.
Yeah, absolutely. Absolutely. And again, for me, it goes right back to that same thing of communication and, like you said, integrity, and goes a long ways in this profession. Mark, let's jump to part two, which was openings at mediation and successfully starting negotiations or taking the next step in negotiations once the mediation has begun.
Well, I tend to disfavor opening statements between the parties. I'm hopeful that they've already done the good work in advance of the mediation by communicating not only with the mediator but with one another on going into it. But if they haven't, I really feel it's my role to serve as the voice for both sides. I can set the tone right. I can calm the tone. I can increase the tone when it needs to be. And so I guess my preference is to not have the parties, I don't mind if it's one like the catastrophic case I was telling you about earlier. We wanted, my client wanted to meet with the family and just apologize from the get-go. And so that's how we opened the day. It was nothing that we are sorry for your loss, and we're here to try to make it right as well as we can, given the limitations that surround us. But in terms of how you start, we tracked it earlier, Kenny, and always being that voice of reason, maintaining credibility, and arming your mediator with the information, the arrows in the quiver, if you will, so that that mediator can start working not for you, but expressing to your adversary what you think has to be taken into consideration for there to be a proper evaluation of risk and reward in order to get that day started right. And so, like we said earlier, when a party is from the get-go focused on a midpoint, when the realm of reason has not even been discussed, it's just too soon. The midpoints matter to me when the parties finally get at least within striking distance of a realm of reason. They don't even have to be in the realm of reason, but at least in striking distance of it for the midpoint to start to matter to me. And I always require the attorneys to start with whomever last offered or demanded, because regardless of how stupid you thought the demand was or how stupid you thought the offer was, today is the opportunity to set the record straight, start anew, maintain reason, and let's move forward credibly. One thing I don't think I've allowed it, frankly, in 5 years is backtracking. I'll tell the parties I'm not going to be a part of silliness. I'm not going to waste people's time. I'm not going to be a source of sheer frustration to anyone, and that's all I get in backtracking. Either a defense attorney dropping the offer, or a plaintiff's attorney increasing the demand without any true basis for the dramatic change. I mean, is there some big piece of information that dropped in your lap that you know about now that really has changed everything? And when did you know about it, and why did you already share that? And so why are we just talking about this now? So again, that's a huge source of frustration I've seen for both sides. And I've never seen anything blow an attorney up faster than the defense attorney or plaintiff's attorney backtracking. Have you ever seen that work, Kenny?
Not once.
Yeah, not once. And actually, it usually takes about an hour, 2 hours, 3 hours just to calm everybody back down and start moving forward legitimately. And so what I often do is kind of back to the credibility. Don't let stupid govern you. Just because you've had a stupid demand or a stupid offer, don't let that control how you're going to take control of the interest for your own client. Real quick story as an advocate. This is several years ago too, but plaintiff's attorney gave me an opening demand that was over the caps, over the policy limits, vastly over. And I told the media, I was so mad. I said, that's just stupid. And I'm leaving if the demand doesn't come down to at least the cap minus $1 or something like that, Kenny. And I said, no, no, no. I tell you what, you do tell him it's stupid, but I will respond to stupid. And I took control of it. Now, what's funny about that, Kenny, is I'd gotten along really well with both the plaintiff husband and the plaintiff's wife in a catastrophic case involving brain injury to the husband. But I got so along so well with them at the end of the mediation, we got it resolved. I shook their hands, and the wife looked at me. She goes, "That really was a stupid opening."
Now, did she
Love
say it in
that.
front of her attorney?
She did. And he was smiling. I mean, we got along. It moved along well. It just was a rough start.
Yeah. Yeah. What, Mark, other faux pas, if you will, or just flat out don'ts from either side at the start of a mediation?
Uh, Not listening. Uh, I don't understand how you go into a mediation and not listen to what your adversary has to say, and talking over your adversary, talking around a problem it's never successful. I promise this to all the advocates that come to me as a mediator, and I've never let one down yet that actually stayed in its chair and let the process work. I promise you, if you stay through this mediation and you truly listen to what your adversary has to say to you, you will learn something about your case today that you did not will appreciate or didn't even know, and it will help you try your case better every single time. And so if you just listen to what your adversary has to say, number one, it's respectful. Number two, you're arming yourself with knowledge. You're giving yourself a better opportunity to make a more informed decision and recommendation for your client. And one other thing I find it mind-boggling is attorneys that don't ask the mediator what the mediator thinks. It's confidential. You can throw it away as garbage. Disregard what the mediator had to say if you don't like it or you just think it's stupid. But then you're at least going to learn something about your mediator. Maybe you need to choose a new mediator, right? So I think listening or not listening, not listening is the greatest source of frustration and the greatest shortcoming I see in an opportunity to achieve settlement, achieve resolution, do a better job for your client.
Yeah, and Mark, once the mediation has begun, parties break off into their various rooms, however many parties or carriers, whatever else there may be. Share some insights with us on effectively working through the negotiation process toward a resolution or possibly toward
Yeah,
the impasse.
well, right. But so I guess working through the negotiations, I like to continue on as started with arming the mediator with additional narratives along the way. You don't want to really, if you're a defense attorney or a plaintiff's attorney, I've never found that just hitting somebody in the head with a bag of rocks right off the get-go is as successful as treating your adversary with some respect, uh, maybe some gut punches, some chest punches along the way with some gloves on or even hand bear, but not just hitting with a bag of rocks. And so I like to dole out the pain for both sides along the way. It gives people an opportunity to not just back up or withdraw or get defensive if you dole out the information in parcels so that people can understand it, appreciate it, and not reject it. Because nobody likes to hear a message that they don't want to hear. And the ability for people to tune out is high if it's not handled well.
I was in a mediation earlier this week, and the mediator used a term that if I'd heard, I didn't recall, but he said, I'm an issues mediator. I've handled a lot of cases like these for a long time, and what I'd really like to do here is help both sides identify the issues, the sticking points, and see where we can work through them together. And that case did not resolve. It didn't come anywhere close to resolution. But it wasn't for the mediator's lack of effort or I think both sides' good faith. I just think it's one that the sides view differently, and we'll come back. I've got a question kind of in part 4 about purposes and goals of mediation. But in hearing you talk, I mean, you strike me as someone who would fall into that camp far more of issues mediator versus carrying numbers back and forth mediator.
Yeah, I don't have any tolerance for just the number carriers. It's just any fool can do that. It's pointless. I love your mediator and the way he or she handled that as a issues resolution tool. Because sometimes sometimes you got a case that just you're not going to get it settled, and the parties understand that it's not going to get settled. But just because the case in toto doesn't get settled doesn't mean you still can't achieve some success by narrowing the issues. I mean, helping both sides say, really, is this what y'all really want to fight over? Or wouldn't you be better apprised to have the jury's focus on this, and this, or the judge's focus on this, and this? Because again, it's how much patience are you going to burn up? How much energy are you going to burn up with that judge or jury? And I'll tell you that with the short attention spans that we all have, seemingly in this day and age, handling your adversary well and narrowing the issues through mediation or otherwise, I think it lends itself to a cleaner trial for both sides. It gives you an opportunity for greater success at the end of the day. One thing I do like to do when I'm working through the negotiations is I like to get some of the standard issues on the table before the 11th hour. What do I mean by that? So do you care about confidentiality? Do you care about non-disparagement? It gives you an opportunity to go ahead and get them locked in. This is what every negotiation going forward is going to involve the following. It's off the table, then you're just really able to focus more on numbers. I also like to go ahead and start talking to parties about, where they are in the litigation, especially when I'm talking maybe to, both sides really, in terms of how much money's invested in experts, how much this comes off a bottom line for either one, depending upon where they are in the litigation. So those are some things that I like to go ahead and get through, kind of partially through. And one other thing I do along the way is oftentimes I'll tell, more often than not, this is my instruction as a mediator to a plaintiff, not a plaintiff's attorney, because y'all know. But oftentimes I'll tell a plaintiff that you have one job today. 2 jobs really. Number one, listen to your attorney. But then your job really is to stay in that chair until your attorney knows that you've gotten every single dollar that you can get on the table. And not leave before you've gotten every single dollar on the table. Because if you leave before you've gotten every single dollar on the table, you're not making the most informed decision that you can make. And why would you do that? Why wouldn't you want to know this is the most amount of money that they say they're voluntarily ever going to pay? And your attorney believes them, and the mediator believes them. So now make your informed decision. But if you walk away before that, you don't know what you walked away from. Do you disagree with that strategy, Kenny? Because I do say it to a lot of plaintiffs.
Yeah, I think it's nuanced. I think like so many things, I think generally speaking, it makes a lot of sense depending on the case.
Sure.
I
And
think
if
in
it's just a waste of time because you see the defenses come in, they haven't evaluated worth of crap. That you're so far apart, it does seem like it's just going to be a waste of time. There's a, $600,000 gap and you're 8 hours into the day, then, I get it.
But no, I mean, I think generally speaking, one of the things I talk about with our clients, co-counsel, uh, attorneys at our shop is if the case doesn't settle at mediation, it's not a failure. I mean, if you considered a mediation, you started at 10 a.m. and at 4 p.m. on a case they never offered a dime, they're offering you $50,000, $500,000, $5 million, whatever the number is, man, that's a good hourly rate. And that's time well spent. The only caveat or kind of the major caveat I'd add is simply and this is more for plaintiffs' lawyers, beginning to give their case away and coming down and coming down and coming down and coming down simply because the defense continues to come up. So I'll just kind of go back to cases worth between $400,000 and $600,000. I'm just using this for simple math again, and I
Yeah.
used example earlier. That's your range, and your bottom draw line in the sand. Never take less than 400. 600 would really be a good day. 500 is the goal. Well, if the defense is offering money, and that's all good and well, and it's 5 o'clock and they're still offering money and coming up incrementally, but you leave that mediation and you're at 600 and they're at 150, I think you've given your case away. So that's the caveat I'd add. But heck, man, if we're still where we need to be and the other side is continuing to move, why not stay around and bridge the gap a little bit and continue to make more progress on the case than you would if y'all weren't together.
Yeah, I take it with your caveat because I agree with that.
But I mean, again, in that example, let's say you're at 750 and they've inched their way up to 300 and they're saying, look, they're never going to pay a dime more than 300. Okay. I mean, heck, I'm okay with that. Because now we went from, again, in that example, $1 million gap to we're 450 apart, and I'm at a number 100 less than where I think my client should consider it, and a couple hundred less than where I think there's a strong possibility they should probably accept things. Yeah, but man, if somebody's offering me money, I think I learned this from Terry Richardson, and there's a famous lawyer down here, Johnny Parker, who talks about it as well. Golly, Mark, and if you're going to offer me money, that's about as good a place as I can be that day. I just don't go many places in the world where someone has dedicated their time to offer me money. So I'm not going to get mad at you for doing it.
Right. I use that same example because sometimes I'll go into a room and there's frustration on the part of oftentimes it's the plaintiff. They've say the defense has just gone up by $20,000. But I often say, I was only out of this room for 20 minutes and you just got $20,000 more on the table. I'm not asking you to be happy about their number, but I'll work for $20,000 for 20 minutes any day of the week. And that's effectively what you just did. So as long as you're kind of getting, Kenny, to that point where you said earlier, you're approaching that realm of reason. It's not a time suck. It's not a time waste, because there is some hope in the future for the day. Then I'm all about just staying in that chair. But I do like that word hope, and it should be hope for both the defense and for the plaintiff. If either party is just depriving the other of hope, then that's the easiest way to kill a day. One of my favorite sayings came from a mediator I respect out of Indianapolis, and it's funny because it sounds like a Southern colloquialism to me. But he says, Mark, oftentimes I'll tell a plaintiff's attorney, you just hung the meat so high in the tree, the dogs aren't jumping. And I'll oftentimes tell the defense attorney, you're fishing with the bait in the boat. I like both of those things because so oftentimes I see one or both being true. The defense is upset, and I'm going, well, you're not even offering pain and suffering, loss of enjoyment with the medicals. I mean, what are you expecting to say or her to say or do? Or, the plaintiff's attorney, you're up so high, they just aren't, they don't feel any risk at all. I mean, you're helping them, frankly, try the case because they get to report the lowest the plaintiff's attorney came to was so-and-so, and I came in with a defense verdict below that amount. So
And I
again,
think
it's
it's one of
about
those,
putting
and I
pressure
try to
on the
be,
risk.
yeah, and I try to be real honest with our mediator of when the mediators who I trust the most, I will tell them in advance of the mediation or very early in the mediation, what we're really trying to do there. And I'll just say, hey, we think this case, again, using that same example, we think this case is worth between 400 and 600. Anything less than 400 never gets it done. Anything over 400 is worth thinking about. 500 or higher is probably a take. Now again, depending on the case, that might not be the conversation. Depending on the mediator, that might not be the conversation. But at least folks have a general idea going in. I try to be honest with the mediator. I don't try to pad things. I don't want to lie about it because, all it takes is one case where they get to 300, we take it. And they say, well, God, Kenny told me they'd never take less than 400. Now they took 300. And I just lost all my credibility with the mediator, and I can spin it a dozen different ways. But at the end of the day, we both know that I was probably the strongest voice pushing for it. And, I've just now, shown my belly. Mark, in the time that we have, let's talk about breaking through impasse and sealing the deal. Because I've been in plenty of mediations and other cases where it just looked like it's never going to get done. And then we do get through it. And honestly, I don't really know why oftentimes, but give us some insight on breaking through an impasse and sealing the deal.
Well, I guess getting past the positional bargaining. So you've already been working through your narrative with your number and with your storyline. You did it from the get-go, and you continued through. But it's just you've played out all the hand that you got to play out. Now it's just down to, if they will go to this, will you go? Then will you go to that? Another way is to bracket. Some people hate brackets. I found brackets with the right attorneys at the right time of day to oftentimes be very effective to get kind of past this whole midpoint scare and let parties truly start to get a feel for where that realm of reason seems to be in the minds of both sides. So that's been effective in my practice. I just learned a new technique from another mediator for whom I have a lot of respect, and he likes to call it nighttime baseball. I don't really understand the name. I just call it as a confidential bracket, and say what he'll do is he'll go to the plaintiff's attorney in the day and say, okay, confidentially tell me what is the lowest that you will accept today. And I'll go in and he'll go in and say the same. What is the highest that defense attorney you will go today? I'm not going to share either number with either side. I just would like to know. And I think this is kind of a hope tactic I think this mediator might use. Number one, are they so far off that he or she feels like it is just a time suck and a waste of the day? Or how close are those numbers? And I think that if you really trust your mediator, first of all, you shouldn't be using the mediator unless you have that kind of trust. But if you have that kind of mediator for whom you have that kind of trust, and rather than just kill the day or have the day just die a bloody end, maybe that is a good tactic. I've never used it yet, Kenny. I'd like to know what your thoughts are on it, because I'm thinking about it on the right mediation when the frustrations are extremely high. Even perhaps I've lost hope as a mediator. I've been mulling it over since I heard about it 2 weeks ago.
I kind of like it. I've never heard that exactly. I mean, we've talked about double blinds. We've talked about, the mediator's number, right? We both go in blind, and unless both sides say yes, they never know the other one did say yes. And for the listeners who don't know what I'm getting at in terms of mediator's number or double blind, what would happen is Mark would come to me and say, hey, Kenny, mediator's number is 500,000. Would your client take 500,000? And I'd say yes or no. Mark would go to the defense and say, hey, mediator's number's 500,000. Would your client pay 500,000? If either side says no, the other side never knows who said yes. But if both sides say yes, you got a resolution. So we've done those double blind mediator numbers, but I haven't done the, hey, what's the highest you pay? What's the least you take? And seeing if those two numbers align. I think that's worth giving a lot of thought to. I think there's some merit there. I'm just not sure what to do with them if they're still apart. So if the defense said most we'll ever pay today is 300, and plaintiff's lawyer says that the least we'd ever accept today is 600 or 700 or whatever the number is, I'm not sure what to do with that. But if they both said, if one said 400, the other one said 450, yeah, that case is going to settle.
So you got me where I go with mediators proposals. I've only done 4 mediators proposals. I don't like them. I don't like being the individual as the neutral that is defining what the number is that is the number. I just don't like it. I've done it on a few occasions, and like I said, just 4. My best example about not using it was I had one a few years ago, and the parties were literally, I mean, they were about $600,000 apart, and both of them wanted me to do a mediator's proposal. I said, "Are you kidding me? You've not worked. Neither one of you have worked. You just have. I'm not going to do your job for you today. Go work." And they came back about a year later, and they asked me if I would resume the mediation and let them try again. Kenny, they got within $30,000 one another. Remember, a year earlier they couldn't get closer than 600. Now they got within 30,000, and they were so headstrong that at that point they said, "We're not going to get any closer. Will you do mediator's proposal?" I went, "Yeah, I'll do a mediator's proposal, given the fact that you did work that hard and you've gotten that close, and it did resolve." But I prefer not to use them as a matter of course.
And that makes sense. I mean, I think if parties are far apart, I mean, if they're 600,000 apart on a $16 million case, I get it. But if they're 600,000 apart on a $500,000 case, that doesn't make any sense to me.
Right.
Mark, this has been fantastic. In the last couple minutes that we have left, any closing words or closing thoughts from the mediator's perspective on best ways to optimize outcomes?
Yeah. Don't always be the smartest person in the room. Listen to what your adversary has to say. Listen to what your mediator has to say. Ask the mediator what the mediator's thoughts are on a particular subject, on a particular number, because you don't have to accept it, but you can learn simply by asking and listening. Speak frankly with your client. I mean, I oftentimes know that it's you want that mediator to give you some cover, and that's what the mediators are happy to do. At least I am. I'm happy to provide cover, but don't undercut the mediator by saying one story that you don't really buy into, but you want your client to buy into what that mediator is saying. There's this disconnect in credibility, and so always maintain that credibility.
Thank you. Mark, for folks who want to get in touch with you about a mediation, and the way that we got introduced was Danny Ellis, who's a very fine trucking lawyer in Tennessee, practices with Morgan Adams. We've had both those gentlemen on the podcast, and Morgan practices in Tennessee, Washington State, number of other jurisdictions. For folks who want to get in touch with you about a mediation involving trucking, insurance coverage, other complex matters, what's the best way for them to reach you?
Just go to my website. It's at harwellhurst.com. HARWELL Hurst HURST.com. And thank you, Kenny. I've really enjoyed getting to know you on our prior discussion in advance of this hour and during this hour.
Yeah, heck, and I'm looking forward. Hopefully, we'll have a case where you can mediate for us. We'll have a fun case with multiple layers of coverage and a truck and some fun issues to work through and do a whole lot of communicating.
I'll look forward to that.
Well, listen, folks, this has been Kenny Berger with Best Practices. Our guest today is Marc Harwell, again, longtime advocate and also a very experienced mediator for complex cases. Keep him in mind on your next mediation, and we look forward to being with you again soon. Hope everyone takes care. Be safe.